Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is equality of value of competition law, a conversation with Professor Eleanor Fox. In recent, months, really since the changeover of the new administration, there has been a renewed emphasis in thinking about competition law in the United States as a way to further break down some of the economic inequality that folks have been talking about. Today, we are very, very lucky to have internationally renowned professor of law Eleanor Fox, really a treasure of the antitrust bar. And she's written on this topic recently. In the abstract of her latest article, she observes that a growing inequality of wealth and income has been flagged as a blight on society all over the world, and that competition law has been identified as both a cause and a cure for that inequality. We will talk to Professor Fox and see how perhaps more aggressive antitrust enforcement could reduce inequality, or whether that alone will do the job. My co-host today is Alicia Downey. Hi, Alicia.
Hi, John.
Alicia, what are we doing today?
Well, our guest today is Professor Eleanor Fox, who is the Walter J. Derenberg Professor of Trade Regulation at New York University School of Law, where she teaches antitrust law, competition policy, and globalization. Professor Fox is the co-author of EU and U.S. competition law casebooks used in law schools around the world. Her work also includes advising numerous younger antitrust jurisdictions in Eastern Europe, Africa, and the Middle East. Her bio would probably take up the entire time of this show, so I can't go into it in much more detail. But without further ado, welcome to the program, Eleanor Fox.
Thank you. Very happy to be here.
Now, we're here because what caught my eye was a recent draft paper that was posted. I think I heard about it in one of the many antitrust newsletters I get every morning. The title of it is Antitrust and Inequality, the History of, parentheses, close parens, Inequality, in Competition Law and Its Guide to the Future. And I gather this paper was produced in conjunction with a conference on competition law and economic equality, in which the question posed was, should wealth and income inequality be a competition law concern? Your answer in your paper and that of your co-author, Philippe Bazanoff, is pretty comprehensive. And so we're going to talk a little bit about that paper. I should let our listeners know that the expanded abstract of the paper will be posted on the webpage for this episode, and that the abstract contains some directions for getting a copy of the whole paper directly from the authors. So, one question that came to my mind just looking at the title. In the context of your paper, perhaps in the context of the conference as a whole, what exactly is meant by the terms equality and inequality?
Well, of course, that is a global question because those words mean different things to different people. I was asked to give a keynote speech at this conference, which was sponsored by the University of Amsterdam, to an audience of mostly Europeans. And that was the genesis of my writing on it. I first thought that perhaps equality of opportunity is the most related equality to competition law, tearing down barriers, having a more nearly equal opportunity to contest markets on merits. And I handed in an outline to my host, and they said, no, the conference is about wealth and income inequality. So I went back to think, how to write a paper for this audience on inequality and antitrust, knowing, incidentally, that a lot, I think more than in the United States, Europeans think there are two huge economic issues not relating to war conflict in the world. One is sustainability and one is inequality. And the point made is these figures are so bad and they're going in a very bad direction, and every discipline ought to ply its oar to make things better. So that's one of the pieces of the background. And the other piece of the background in terms of people working on the issue is there have been a number of papers in the last 5 or 6 years claiming that antitrust and its misuse or non-use is in fact a cause of this greater inequality of wealth and income, on the theory that there is more market power and higher markups, and that the distribution goes predominantly to the rich or very rich and predominantly away from the poor and the middle class. So I read a whole lot of literature on it, and I read claims one way and the other saying, oh, yes, antitrust causes or is a good cure for inequality. And a lot of it being economic and statistical. And after I finished reading all the literature, I thought, what can be my contribution? And came down to the history of the value in competition laws across the world.
I think the paper does point out that seems to be a gap. A lot of the people who've written on the subject really do come at it with sort of the conclusion in mind, and they're writing a paper to persuade the reader of the rightness of their conclusions. And I think it's fair to say that the bulk of your paper is descriptive, although, toward the end, of course, there are some recommendations and some, suggestions for both the development of the U.S. antitrust regime, but since you do work with so many other countries, perhaps some ideas that they can take away as well. But focusing then on the U.S. and the work that you did looking at the history of that equality, income and wealth equality value here, what should we know? What were some things that you learned or that perhaps surprised you?
Of things that I perceived, because I might not have been surprised, I've been practicing antitrust law in the United States since 1961. And I knew very well in the 1960s period, which was the Warren Court period, that antitrust was naturally sympathetic to a better distribution of wealth and income to those who were on the outside, not the inside. And I also knew and lived through the great antitrust revolution of the Reagan era and the judges Reagan appointed and the new acceptance of the Chicago School, that all of that was overturned and antitrust became a vehicle for efficiency. That was a real revolution. So what I've said in the article is, yes, antitrust in the U.S. used to include an equality value in terms of sensitivity and consciousness for who were the losers in the economy and how to get the outsiders a better path to contest markets and have a more nearly equal opportunity to compete on the merits. And so it was in that direction, and that was taken out of the law in the 1980s and has been out of the law since the 1980s. It's been cold antitrust rather than hot antitrust.
And I think, though, what's very interesting, and it's coming back. I think you see that in some of the things that are going on in the new administration.
Yes. So definitely coming back in the rhetoric, but not coming back in the courts. And this is a problem or puzzle because what I see is the rhetoric is very strong today that equality consciousness ought to be a value in competition law. And when I say that, it's a very broad word, and we can get into more details later. But consciousness of who wins and who loses. And if the persistent losers are always the poorer people, the idea that is that something is wrong and maybe our rules should be changed. That's the rhetoric. And I think it's a very powerful rhetoric, but it's not in the law.
Is there a particular line of cases, or even perhaps one Supreme Court case, that you think embodies sort of the abandoned approach to antitrust law that does incorporate equality value?
GTE Sylvania in 1977 says we're not going to put non-economic values in our law. And the dissent and partial concurrence by White says these values have been more deeply embedded into our law than the free rider argument that the Supreme Court now invents. I think that was a turning point. If that had not been done as early as 1977, it would have been done in the early 1980s.
Professor Fox, I would have pointed to Trinco. And maybe Trinco is...
Trinco kind of digs the heel in and cements it further. But you don't have to wait as long as Trinco.
Yeah, I mean, I think that's right. That may have been the turning point, but Trinco was the point where we went over the precipice, I think.
I agree. I think one of the things that I find really important, though hidden in Trinco, is that as everybody knows, there are technicians and in the antitrust field who read the cases carefully. This case was thrown out on the complaint, and the complaint alleged, and the FCC also had found that the predecessor to Verizon had actually created noise in the system so the new entrants wouldn't get customers of it that would gravitate away from the incumbent to the new entrants. And the plaintiff alleged lots of incidents along this line, and the states wrote a brief that said, we have to deal with 1,000 cuts, all of these small slights to us, make us marginalized competitors. And the Supreme Court said, oh, well, we can't deal with such things. How can courts deal with all of the 1,000 cuts? The courts aren't fit to do that. We have to recognize that even monopoly firms need a lot of freedom of action in order to have sufficient incentives to invent and invest. So I think Trinco definitely dug it in, but it was really way before Trinco that turned around.
No, I think that's absolutely right, and I found it interesting, and Query, you've said the rhetoric has turned around, and I agree with you. Query was when that turnaround started to happen, right? Because I think you saw the DOJ put out its unilateral report on the very last days of the second Bush administration, and then one of the first acts of the new Obama administration was to say, no, that's not right. Is that is that a moment when things have shifted back? Because I do think you're hearing the rhetoric, although it is very, very hard. To your point, once the courts make a decision, it is very hard to turn that around.
So I would say no, that the difference between the Section 2 report that the Justice Department wanted and even what the FTC wanted and didn't get, and what the Obama administration said it wanted, was not about non-market values. It was on the continuum within the realm of we're applying market values, the continuum of laissez-faire versus progressiveness still within market values. They were never saying we want more equality. There's a huge range of thought, and some of it, if you put equality consciousness in, will move the law in a direction that actually is very defensible on efficiency grounds. So my point is, for example, that the decision in Trinco is an inefficient decision, that it creates high barriers for new entrants to get into markets. It gives too much of a presumption for incumbents to do what they will. And that if you have an equality consciousness, that could drive you in a direction of more antitrust for lower barriers to entry that's also efficient, and equity and efficiency meet. But you don't have to use the equality word to get to the point of rejecting the Section 2 report.
And I think your paper does a nice job responding to both the proponents of injecting more a consciousness of inequity and resulting inequity into antitrust analysis, as well as the critics who might say it's infeasible, it's un-American, or it's simply not in line with economic theory.
Right. So again, you can see a continuum, and this is why I chose South Africa as one of my countries for studying, because of the countries that I studied, and also Philippe Bazanov, with whom I wrote. The countries that we studied range from the United States, which says, no, we don't deal with equality values here, to South Africa that says, post-apartheid, our biggest objective was dignity and equality of people, and we're going to use all law to try to get there. And it self-consciously uses more near equality for the left out Black Africans to get into markets, to have ownership in markets. So there's a real difference between using an equality value when you're going to be interfering with market competition and efficiency and saying, we want this trade-off anyway. And South Africa does it. And what I'm recommending for the US, which is to say, with equality consciousness, you can see a little better how the law is favoring the incumbents, and that means power and privilege. And it's not giving equal treatment on the side of entry. And I'm trying to work in this space where I say efficiency and equity overlap. But I'm also saying if a country like South Africa wants to take on the value and pay the costs of greater equality, they should do it carefully and with recognition of trade-offs.
I think the other thing that's kind of interesting about South Africa is embedded in the law, and we talk about equality, but other values embedded in the law is a real focus on labor. And as you do, as folks I think who do merger clearances in South Africa know, when you do a clearance, you have to explicitly take into account the impact that the merger would have on labor. I think that probably goes back to the fact that the anti-apartheid folks who ultimately took over the country started out as trade unionists. Having said that, it's not like having embedded that value, South African merger, focusing on merger for the moment, but merger control law has gone off a cliff. People still get mergers through in South Africa. There's a very strong antitrust bar there. The regulator is pretty strong as well. I mean, they've added this value, but it still works.
That's right. So I would say that adding the value of consciousness about the particular workers who are affected negatively by a merger, usually a big foreign merger, is definitely using equality or more near equality as a trump, even at some cost, because it does there run against at least short-term efficiency of the company, because the company usually has to pay the salaries of people that it can't fire for, say, 3 years. And so South Africa is now developing some ideas as to how to make that kind of mandate more market friendly. Maybe lump sum to the employees who can go out and now invest and participate in markets rather than just salary for doing nothing at the job. So it is a question of values and whom you want to protect. It's also for South Africa a question of the employment situation, where almost 50% of the youngish people don't have jobs. And for big mergers that threaten to cut out a huge number of jobs are considered a very big social cost that that contributes to social unrest. And so there are deep societal problems that are woven through various disciplines of law.
Now, if as I mentioned, your paper has some concrete suggestions, perhaps bringing the equality consciousness back into the U.S. regime. If the courts are really not the source of hope, though, and I think you were pretty clear about that, are we talking about legislative changes at the federal level, FTC? What needs to happen?
Okay, so I'm talking about both. About working in the law, but I don't have much hope for working within the existing law, and possibly some legislation. But some of my recommendations are pretty mainstream to the extent of saying that they basically correspond with getting markets to work better, and that, in my view, our law is outdated by giving so much benefit of the doubt to incumbent firms and so little concern for channels of competition for smaller firms. So my recommendations, and also just no concern for distribution. On a theoretical argument, how can we be concerned with distribution? Antitrust is all about allocation. We don't care about distribution. If we think about allocation, we'll make the pie bigger. Everybody will get a bigger share. We know that everybody doesn't get a bigger share, which is exactly the rub. So one of my recommendations is to say that we really ought to pay attention to who wins and who loses. And that if the poorer population are constantly the losers, maybe something is wrong with the law. A related recommendation is to say that the way we have been doing economics is using Calder-Hicks, which is if the winners win more than the losers lose, that's efficient and you shouldn't touch it. And I am saying that it would be a really good idea to disaggregate, say you're using consumer welfare standard, to disaggregate who are the consumers. If the rich consumers are always winning by having a rule that companies can have resale price maintenance, but poor consumers are always losing, that ought to be relevant. Of course, it's not now, Alicia, and that's what you've asked, what to do if it is not now relevant. Talk about it. If people agree that that is a problem, it might lead to legislation, or it might lead to consciousness on the borderline where you could go one way or the other on aggregate efficiency values. But if you break out the aggregate and see poorer people are always losing, you might want to have at least a very strong presumption that resale price maintenance, if that's it, is anti-competitive.
I guess another place you could do it is in policy choices, right? Because ultimately, if you're at the agencies and the agencies have a choice between litigating two different mergers, back on mergers, but I don't mean to be obsessed with mergers. I mean, it could be a conduct case as well. But if the agency have a choice between the two, and they start choosing to litigate the one that would vindicate the equality value more, that could have an impact as well, I would imagine.
Yes, that's certainly right. And that indicates that agencies ought to have a very high concern in priority choices for markets where lower middle class and poorer people are affected, and food, agriculture, healthcare, energy are all in that segment. I do believe that the agencies are very conscious about that segment. So I do also urge prioritization. I'm not sure how much difference it makes, but because I think agencies will say that they're doing it all along, but I think it's very worthwhile to keep saying it because it's very important. And incidentally, on the Calder-Hicks, it's not just antitrust where this has arisen. I've seen this idea that we really ought to consider who are the winners and who are the losers. In environmental law, it's becoming an important factor, at least from some scholars who are saying we're letting certain things happen environmentally when aggregately they seem not to harm the environment, but they really harm poor people. And there should be consciousness about that.
Why don't we switch gears quickly, though, because we're kind of coming almost to the end of our time. We don't often get somebody who's been practicing antitrust law since 1961 on our program. So this is a rare opportunity to ask you. Now, you've been teaching for how long in law schools?
For 40, going on 46 years.
Oh, okay. For just that little amount of time. What to you has been one or a couple of the biggest changes you've observed in the law schools?
Right. So I certainly have observed the students and faculty changes over the years. And I'll have to stick a lot to my own law school, which is New York University School of Law. And my own law school, there are two really important changes, really dramatic. So one was even before just before I started teaching at NYU Law School. The law school and many others became much more scholarly and oriented towards concepts and literature that could be philosophy and economics. Economics came into the law in a very, very big way. Philosophy and history come into the law and are discussed. So for many years, there was a trend towards more scholarly thinking. And then I'd say maybe about 15 years ago, a movement to say that the law schools are becoming too dissociated from professional practice and also need to be much more in tune with what is necessary to train the lawyers for the law firms. The other is both diversity and cosmopolitanism. I think certainly my law school, but certainly others, have opened their doors and laid down some barriers. And there are many more people who are students, but also professors from countries around the world. This has been extremely enriching. And certainly it's happening in very big measure in my law school. And it's really a great pleasure to be able to interact on a daily basis with faculty from South Africa, Australia, South America, obviously Europe, on a day-to-day basis. And students also, very enriching.
What advice, if any, do you have along these lines? What advice, for any, do you have for law students, aspiring young lawyers who want to have a successful and fulfilling legal career?
Well, I usually say to my students two things. Know who you are now while you are in law school, and don't give up your humanity. Don't get honed down by technicalities and look beyond. And the other is follow your star. Think what you really want to do to make yourself happy, which might mean and often is to make the world better. And have a vision that you pursue. Make yourself happy and do good. Of course, I mean, the do good was sort of gratuitous there. People can do what they want to do. They can go make a lot of money if they want to. It's not the track that I'm on or have been. And I really love to see students actualizing themselves and contributing to society.
It's funny, and it's probably a subject for another program, but I would imagine too, Professor, that one of the things that has changed, I mean, maybe not that much in 20 years, but certainly compared to 50 or 60 years, is the number of women in the profession.
Oh, absolutely. Yes. Yes. When I graduated in 1961, there were almost no women in antitrust at all. So I was almost always the only woman in the room. And now I think it's about equal, isn't it? Do you find it's about equal?
Yeah, like I said, still work to do. I mean, what I see is in the law school classes, they're more or less equal.
Well, let me correct you. I teach an antitrust class at a law school where the enrollees are 60% women and 40% men. My antitrust class enrollment is 66% men.
Well,
that's interesting.
we certainly have work to do, and my observation, and it's a point well taken, Alicia. My observation was really at the beginning phases, you see more women. By the time you start looking at where you start getting later career, at least the law firms have to figure out how to do better in terms of retaining and promoting women. And places like if you look at the agencies, the antitrust agencies, I think you see there's quite a bit more diversity, and perhaps not coincidentally, those are often identified as really good places to work.
Yes, I think that's right. The antitrust agencies have always been more diverse than the law firms. When I was a very young lawyer, I remember going to the FTC in New York and just to myself, commenting silently, wow, there really is good diversity. I mean, racial and gender. There's really good diversity here and not in the law firms.
All right, and let me ask you one more. Tell us something interesting about yourself that we wouldn't know about you if we only knew you professionally.
Oh, okay. So I'm not sure what to tell you, but I will say that I didn't start out life or later life thinking that I wanted to be a lawyer. I wanted to be a writer. I wanted to be a novelist or a short story and poetry writer or a journalist. And so law became interesting to me just because I thought, gee, this is interesting. And then, of course, it took on a life of its own. And I always thought, even when I went to law school, that I would do my expository or literary writing at night and weekends. But, law really takes over your life a lot. And so that has been put to the side for a while.
Now, Google tells me you published a novel.
Oh, yes. Yes, I published a novel, W.L. Esquire, which is kind of a comic novel, and it was written in the mid to late 1970s, so very different period from now. And it's a feminist novel about how women are really managed, belittled, or put on a pedestal, but not given the equal chance. They might be given sometimes more, sometimes less, not equal chance. And the WL stands for both women's liberation and main character Wendy Lieberman, and it's WL Esquire. The Esquire is gentleman, that she can't really go up the ladder more without being a gentleman. But of course, she can't be a gentleman because she's not a gentleman. So she hits the glass ceiling.
That's great. I'm going to look for that novel and try to find a copy in print somewhere. Well, with that, we're going to switch over now to our final segment, which we call Free Advice. And this is where we ask some of the world's leading antitrust and competition authorities to give us some free advice in response to actual questions submitted to advice columns about topics that have absolutely nothing to do with antitrust and competition law. Now, today's selection is from the July 11th, 2021 issue of Anchorage, Alaska Daily News. And this is the advice column by Wayne and Wanda. No last names, just Wayne and Wanda. Here we go. Dear Wayne and Wanda, now that fishing season has started, all my boyfriend wants to do on weekends is fish. Go where the fish are, camp where the fish are running, etc. This means nearly every weekend we leave Anchorage after we get off work Friday night and show up late at some campground or parking lot and get a bad night's sleep. Then he fishes basically every waking hour until we finally drive home at the last possible moment. We barely spend any time together. I spend most of the weekend by myself in a campsite, reading and hoping I don't get visited by bears. We're pretty serious about each other and have discussed marriage down the road, but I'm just not having fun with these frantic weekend fishing trips. Is there a way to compromise, or is it time to throw him back and find a new catch? What do you say, Professor Fox?
I think let him go fishing and find your own love of life. I'm not talking about another man. Your own love of life in terms of what you like to do while he goes fishing, whether it's reading books or writing books or walking through cities, whatever. Find your own track and see if that works.
Well, thank you, Professor Fox. You have been a wonderful guest. You've given us fantastic free advice and, more importantly, very interesting food for thought. And we'll be very interested to see how issues of inequality continue to percolate up in antitrust law.
Oh, so thank you, Alicia and John. You've been great hosts, and this has been really fun. Thank you.
All right, check out the article. It's going to be on our links, and we'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.